A taxpayer lawsuit challenging the government's controversial $190 million power purchase agreement with Saipan Development, LLC is still pending in Superior Court. This afternoon, Judge David Wiseman heard oral arguments on Saipan Development's motion to vacate a preliminary injunction imposed on the deal. Representing defendant Saipan Development, attorney Bill Fitzgerald told the court his client has been unjustly portrayed in the media as corrupt, and he suggested that keeping the injunction in place reinforces that view. He also argued that the injunction should be lifted because it's irrelevant.
The injunction is irrelevant at this point. There's not going to be a contract. As I said before, it takes two to tango. If the government doesn't want to go through with it, there's nothing we can do to make them go through with it.
Representing the plaintiffs, Congresswoman Janet Maritita and the CNMI Senate, attorney Ray Kitutu told the court the injunction is very much still relevant. He also noted that both CUC and the CNMI government consent to the injunction. Indeed, CUC attorney Deborah Fisher urged Wiseman today to maintain the injunction to preserve the status quo until the court decides whether the power purchase agreement is void or not. Kitutu agrees.
There's still a PPA that's still a contract, a life contract. So that's the very thing that we're trying to have the court declare void. And so, of course, it's relevant. You know, the effects of it against the people of the CNMI are still very real if the injunction orders are lifted.
Although Attorney General Joey San-Nicolas issued a legal opinion last December declaring the contract void, both Kitutu and Fisher noted it's just an opinion and uncertainty remains until the court issues its final ruling on the matter. Kitutu also suggested that Saipan Development may still sue the CNMI for breach of contract, and Fisher expressed concerns that if the contract is not void, CUC may be on the hook for paying the firm between $17 to $19 million in penalties. As for comment, Fitzgerald.
Does your client intend to sue for breach of contract, as was suggested by the plaintiffs?
We haven't decided yet.
So you still could sue for breach of contract?
Yeah, we may be entitled to damages, but that remains to be seen, and whether or not Saipan Development decides to pursue that still is up in the air.
Fitzgerald adds that keeping the injunction in place would not prevent his client from suing for damages. Asked if Saipan Development might pursue litigation even if Wiseman declares the contract void, he says this.
And you'd have to take it step by step and see whether in Saipan Development's view it's worthwhile to continue litigating. I mean, the point being, how many unpaid judgments do we see that were announced in the paper the other day? So even if they would win, what would they get?
Judge Wiseman took the matter under advisement. Wiseman also heard arguments and took under advisement the government's motions to dismiss former Governor Ben Fitiel from this taxpayer lawsuit. Fitiel is being sued in both his personal and official capacities. The government proposes to substitute the CNMI for Fitiel. Assistant Attorney General David Lockaby represents Fitiel and argued in part that the former governor has qualified immunity under the law.
Government officials are entitled to qualified immunity for actions when they get sued over actions that they take during the course and scope of their employment, unless they violate clearly established law of which a reasonable person would have known.
According to Lockaby, Fitiel reasonably relied on the legal advice of then Attorney General Ed Buckingham and believed he had the authority to sign the contract with Saipan Development using his emergency powers. Attorney Ray Kitutu opposed the motion, arguing that Fitiel was not reasonable and Buckingham's mere signature on the contract doesn't count as a legal opinion. Lockaby.
So the rule is that government officials are allowed to may rely upon the advice of the Attorney General. And our position is that when the then Attorney General signed off on those documents, that was advice. He's advising it's a functional equivalent of somebody saying, yeah, this is okay, go ahead, you can do this.
The Attorney General's office is also representing Buckingham in his official and personal capacities. Assistant AG Charles Brasington filed earlier motions to dismiss and substitute for Buckingham as well. Wiseman has yet to make a decision on those motions. Meanwhile, the former AG is facing criminal charges filed by the Office of the Public Auditor, including one count related to his legal review of the power purchase agreement. According to OPA, Buckingham knew or should have known that the contract was illegal. The former AG is now a fugitive of justice and believed to be in Iowa.